This lawyer thought AI would save him in court, but instead the judge discovered his entire filing was fake.
AI application to file legal documents.
What happened next shocked everyone in the courtroom.
All right, this is the 1 p.m. calendar. This is Ada Molina Costin Cruz versus Diaris Nellums, Peachtree Truck Leasing versus ProMed Imaging and Unified Medical. But essentially, the case took a turn because at the last meeting, the attorney for Caston Cruz, the plaintiff, Mr. Tristan Gillespie, presented a document to the court that had, I guess, was created by an AI application, an artificial intelligence application, and there were cases cited to and presented to the court as legal authority that did not exist. And so the court made a record, assisted by the Mr. Kennedy, who's the attorney for the defendant, who had gone through and basically noted all of the instances where there were documents, where there were cases cited in the document, but they did not, were not actually cases under Georgia law to which the court could lean for legal authority. All right, so at that point, I informed Mr. Gillespie that I would be sending this information to the state bar, which I did. And I have not heard back from them other than that they have received the information and it is in process with the general counsel for the state bar. But I did tell Mr. Kennedy and Mr. Gillespie that we would reconvene to determine what sanctions, if any, the court would impose. All right, and so I have Ms. Middleton. Yes, ma'am.
Good afternoon, Your Honor. I represent Plaintiff Cruz. We filed an entry of appearance on December 31st. I left counsel a voicemail this morning, and we do have plans to connect after this hearing.
All right, so Mr. Kennedy, I did ask you for your suggestions for the any sanctions that the court might issue in this case. But I think I need to hear from Mr. Gillespie first, because Mr. Gillespie, I gave you an opportunity to respond. And essentially, from what I understand, the basis of your response is that you relied upon the app to assure you that it was correct.
That's right, Judge. I'll confess the technology is new to me, and thanks to this case and the motion and Your Honor, certainly much more educated about the pitfalls and dangers and so forth. And clearly, it's not sufficient to rely on large language models to, I guess, verify or validate case citations, and so much so that we went through the effort and expense of getting proper legal research software, which of course I use solely now, rely on heavily. So I think at this point, before we get into a discussion about any possible sanctions, I think it probably would make a certain amount of sense to wait to see what the Georgia Bar thinks of my response. I think it would be premature to impose any sanctions until we saw if they saw any validity to the defense that I raised and that I just explained.
Okay, Mr. Gillespie, apart from what the bar might opine as to the response that you gave, you filed a pleading with the court that was replete with cases that did not exist and were not, in fact, legal authority. And as a member of the bar, you're responsible for whatever you file with the court. And if you file information that is incorrect, erroneous, untrue, then you're responsible for those filings. You have delayed the course of this case because I could not even undertake the matter the primary matter that involved the plaintiffs and defendants in this case, I had to spend court time addressing the fact that you sent in a brief that was essentially fiction. And so, based on that, what the bar decides to do with respect to your violation of the legal canons and rules that govern members of the bar is separate and apart from your wasting court's time, you're diverting the court's attention from the primary issues in this case, and taking away from the plaintiffs and the defendants' opportunity to be heard. You've elongated this case in a way that wasn't necessary, because now the court does not have faith in your ability to represent the plaintiff in this case. I'm appreciative that Ms. Middleton has come into the case to represent Ms. Caston Cruz, because I would not feel comfortable going forward with you as the attorney solely representing Ms. Caston Cruz based on your performance here before the court. So, Mr. Kennedy, did you have a suggestion for what you wish to have happen in this case?
Yes, Your Honor, and I did file the motion for sanctions, which you encouraged me to file after our last hearing. And I would just point out, I mean, it's not just like this was one brief, this was several briefs that were filed before the court that contain these same problems. And I think bare minimum under OCGA 915.14, I would ask for my client's reimbursement of all of our fees.
From Tristan's iPhone.
All right, don't know what that was.
Go ahead, sir.
Yep. All of our fees up to this point, because like you said, basically all we've done at this point is deal with these issues. We haven't even gotten to the substance of the case, and it's already been, we're getting close to a year since the complaint was filed. And it's just been a waste of time and an expansion of the case to this point. But I would also ask you to just dismiss this case, Your Honor. I think as you pointed out in our last hearing, the content or the conduct has been direct contumacious conduct to the court. It's written documents submitted to the court as legal authority in support of legal arguments which have no basis in Georgia law and are just fictitious. And we can't live in a system where this is how we operate, and it's just not how the process is supposed to work. We can get into the way this case has gone down too, but we've had issues with getting discovery responses. We've got a summary judgment motion pending right now based on failure to respond to discovery. It's not just only the AI and use of AI, which I'll also point out, you gave him a chance to tell you this last time, and he said nothing. We called it out and we asked him what was going on, and the response was, you want me to provide additional briefing? Or just, oh goodness, not sure how that happened. And now we find out he knows exactly how it happened, and he knew then how it happened, and he didn't tell us. And that's just a violation of the lawyer's basic duty of candor to the tribunal, Your Honor. And I don't think that bringing in another lawyer necessarily absolved all the prior behavior and, sins of counsel, so to speak. And you can just now wash it all away and move on because we've got another lawyer involved. I mean, my clients have been prejudiced by this. We've got significant questions about this case anyways, outside of all these issues, which I'm happy to get into further. But I would ask this case be dismissed and my clients be reimbursed for their fees and expenses up to this point. And I provided you an affidavit as to that number back in August when I filed the motion. It's part of my motion for sanctions, where I also outlined all the instances of the cases that have been either are just totally fictitious or were cited for like a completely different proposition than what they were, than what the cases actually say. And so that's Exhibit D to that motion. It's my affidavit of fees.
All right.
If I may add, Your Honor, we don't disagree with the procedural history of this case, but we would like to object to counsel's dismissal.
Wouldn't be my dismissal, it'd be the court's dismissal, but.
Well, your suggestion of the dismissal.
Okay.
Dismissal. Okay. All right. Well, you say you're objecting, you got to give me some basis for your objection.
Yes, Your Honor. So the plaintiff here has terminated previous counsel. It's my understanding previous counsel has also been terminated from the firm as well. My basis on the objection would be that plaintiff had, no idea this was going on, and as such, shouldn't be prejudiced because of this. My goal would be to get this case back on track. It's my understanding there was a consent motion to discovery filed with discovery expiring, I believe, the first week in March. So we would want to be as diligent as possible and still maintaining that deadline and getting the case back on track.
I want to be mindful that the parties in this case are not the primary drivers when it comes to filing motions and attending to court processes. And so, if I'm going to sanction in any case someone who's acting on behalf of the parties, if Miss Caston Cruz is unaware that her attorney is filing fiction, it would be unnecessarily punitive to her. I get that the case has not moved in a manner that is expected. But civil cases tend to have issues with timing anyway. Civil cases can, there's no real expectation of how long a civil case is going to take. We hope for things to be done in a timely manner. We have a structure for how discovery should be conducted. We have a structure for how cases should proceed, but mere timeliness is not something that we can really. That's really a factor that we can guess about or know about from the outset. What I do have is a desire to make Mr. Kennedy's clients whole, in as much as he's had to respond to these motions, he's had to spend court time, he's had to spend office time, he's had to address all of these filings, and then the volume of the filings, when really to tell me to file a huge filing just to tell me that you relied on ChatGPT to tell you that ChatGPT was right. We had a training for judges about the use of AI, and essentially the main thing that was beaten into our heads was you are responsible for everything that is produced, whether you use an artificial intelligence application or not. There are ways to use it to effectively manage the workload of cases and documents and having to read tons of filings, but you can't rely upon, especially something that is open source material at this point, like ChatGPT is open to anybody, and it is not an application specifically for use as a legal artificial intelligence engine. It is software for people. One of my friends uses it as, she says, like it's like her wife. She'll say, hey, make a grocery list. Hey, write this letter for me. Hey, set up a schedule for my children. And so it is assistive in that way, but you are responsible still, because I'm so old school that this is the phrase that keeps coming to my head: garbage in, garbage out, which we were all told when at the outset of, and I'm old enough to go back to when we switched from typewriters to personal computers and to software, to the software for personal computers that allowed us to type and produce documents. And so at this point, I'm not inclined to dismiss the case, because I really feel like Ms. Caston Cruz has no clue about the breadth of issues that have popped up that have nothing to do with the merits of this case. However, Mr. Gillespie, I'm not inclined to just wait until the bar resolves it, because that has nothing to do with the fact that you have caused an inexcusable delay, that you have not been candid with the court, that you have not done what is necessary for all attorneys to do, which is to manage your work product and make sure that you are producing products before the court, and giving case law and statutes upon which the court can rely. And so, with that being said, the court is inclined to grant the sanctions asked for by the defendant, Mr. Kennedy, and to make those sanctions personally payable by you. They are not to be borne by the party in this case, Ms. Caston Cruz, or the firm. Those are sanctions that you should bear yourself, because it was you who made the decision to rely upon an open source AI application to file legal documents, and to not go back through those legal documents to ensure that the case law that you presented was reliable, was true, was not erroneous, was in fact actual case law that a court could rely upon. And I saw it, but I can't find it now. What is the amount that you're seeking, Mr. Kennedy?
So as of August, when I filed this, it was $25,498.08. That's fees and costs.
All right. So, Mr. Gillespie, there will be a judgment against you personally, a sanction against you personally for the amount of $25,000 for $25,498.08 to be paid to Mr. Kennedy. Is that to be paid to your firm?
Yes, ma'am. And then we'll get it back to the insurance company who's paid it.
And Judge, just so I'm clear, that's the entirety of his fees from the beginning of the case till today?
Mr. Kennedy?
That's correct.
I'm not hearing you invite a response to that, but that seems excessive. I understand that that your opinion that I have caused undue time and expense expended by him, but what I have not heard you say is that 100% of all of his time and thus that fee is attributable solely to my alleged transgressions.
Mr. Kennedy?
I didn't go through and itemize. Like I said, this is just for the whole case. The way I've kind of viewed it is this is all we've been doing in this case so far is basically, him filing, me responding to these types of briefs. But Judge, if you want me to go through and itemize it further, I can do that.
I'm not inclined to do that, and this is why. One brief I could understand, but if this is the tenor of the type of practice that Mr. Gillespie has engaged in this court, and in this case, so I'm not going to nitpick at this point. I feel like from the outset of a case, if you're not practicing law the way you're supposed to practice law, if you are not making sure that you are attentive to the reliability of what you file, the truthfulness of what you file, if you are filing things with no regard to to what your client is entitled to the representation that your client is entitled to, then I do not believe that is an excessive amount. So $25,498.08, that's to be paid to Mr. Kennedy's firm. That is not to be borne by anyone but Mr. Gillespie.
Judge, is there a timeline you want to put on that?
120 days.
And would you like a proposed order, or will you have one?
Please submit one.
Okay. Your Honor, if I may, I know you've indicated you're not inclined to, dismiss the case on a sanctions ground. Are you planning on taking up the summary judgment motion today too?
Ms. Middleton, you're just coming into the case. Can we get back on track with the merits of the case?
I believe so, Your Honor. In all honesty, I have not had a chance to really take a look at that motion for summary judgment. I did see some mentions of reopening default in the docket. If counsel's willing to get this back on track with discovery, I mean, we would have no reason to oppose that, and I'm happy to get on a call with counsel once this hearing wraps as well.
Here's
Okay.
my only issue, Judge. So I filed this motion for summary judgment because they didn't respond to requests for admission, right? So under OSCGA 1136, those are just deemed admitted. And the case law is very clear that to overcome those deemed admissions, they've got to provide credible, admissible evidence that would refute them. And there is none right now. I mean, they filed a reply brief that had an affidavit from their client that is inaccurate, and we can go through it if you want. I can show you exactly why. She's got, first of all, a different date of a motor vehicle collision, saying I was involved in a motor vehicle collision on January 4th, 2024 on I-20 in Douglas County, Georgia. And can I share my screen on here?
Your Honor, if I could be excused, I know a lot of this going forward doesn't pertain to me.
Yes, Mr. Gillespie, you may be excused. We'll get you in order.
Can you see my screen, Your Honor?
Yes, sir.
Okay, this is the police report from our case. As you can see, I can try to.
I have December 14th, 2023.
Right, in Gwinnett County, totally different day than in her affidavit, sworn affidavit that has been submitted to this court, which again is just kind of consistent with how things have gone, says that this is the day that she got in a motor vehicle accident and was injured. I mean, I don't know what to do at this point. That's all. The only evidence they have, apparently evidence in quotes, is this affidavit from plaintiff that says she was injured in a motor vehicle collision on a completely different day that she supposedly received medical treatment for. But then again, we've got these requests to admit that they're deemed admitted that basically say, my medical treatment wasn't caused by this accident and wasn't necessary, and those sorts of things that just completely defeat her case. So at this point, I'm not sure there's a lot to even argue on their side as to how they overcome a summary judgment motion. So that's why I was asking I know you're not inclined to dismiss it on just a pure sanctions ground under 915.14 or because of the contumacious conduct to the court, but I think I'm also entitled to you granting summary judgment in my favor.
All right, Ms. Middleton.
I mean, the fact that there's a police report showing that the wreck happened, I mean, obviously there's some meat there. I mean, we would obviously object and request for an additional 30 days to respond to the motion for summary judgment, if you would be inclined, Your Honor.
Well, kind of not, because at the point where I guess you came into the case, we had been dealing with the sanction issue, and that has been more than 30 days. So from that point, Mr. Gillespie and the firm and whoever he's dealing with had noticed that there was a pending motion that the court did not hear, and that there was time at that point to address that pending motion or to come up to speed on what that was. And at this point, the court's not inclined to continue to delay this issue. To Mr. Kennedy's point, if the discovery is deemed admitted and we're dealing with the basis of, okay, these facts are a part of the record, then you have to come with the strongest evidence to show that the deemed admitted facts have that there is something to counter those facts that have been admitted by failure to respond to discovery. So just the fact that there are two police reports or two incidents of an accident, one in January of 2024 and one in December of 2023, the existence of those divergent things is one thing, but none of that is enough to overcome what has been admitted.
I'll also just point out that she also in the affidavit says that she was struck from the rear by a vehicle. And I can pull back up, but the police report from our case, she was backed into. So it's like a completely different mechanism of the way the accident happened too.
And, given the procedural history of this case, Your Honor, I do think we have good cause to possibly withdraw or amend those admissions. I would want to move to do that.
Well, that's already been done.
This is
I know.
this is the issue that I'm having, though. Y'all have, I don't know how you got into the case, Ms. Middleton, and so I don't want to beat up on you too bad. But the issue is that y'all have had plenty of time, because since we had the first sanctions case, I know that was probably sometime in early October, or I feel like it was October.
August.
It was okay. It was August, because I've gone to judicial training since then. I've come back. We've had the holidays. So since August, we've had a substantial amount of time for you to file whatever you wanted to file. Because had I decided to accept your filings, fine. They're already on the record. Let's deal with them. But I didn't restrict anybody from filing anything. The only thing I asked for at the point that we left in August was for information about the filings that involved Mr. Gillespie and the sanctions. I don't know when you came into the case, but there was plenty of time entering the case to file whatever was necessary to protect the rights of Ms. Caston Cruz. And so if you didn't make use of that time, there's not a lot I can do in this case.
Well, and Judge, I mean, they did file a response to my motion for summary judgment, and they did file a motion to amend or withdraw their deemed admissions. It's not like nothing's been briefed and been filed. I mean, this stuff was all briefed and is in front of you, and was briefed back in September and August and October.
The issue is, though, that I don't have a lot of information that says we need to overturn the admissions and reopen that part of the case. And also, I'm kind of leery of what was filed, because it was filed by Mr. Gillespie. At this point, the court has no confidence in the validity, viability, or legal basis of anything that Mr. Gillespie files with this court.
So am I taking that as you're disregarding basically his response briefs and the pleadings, the briefs he's filed? And at this point,
unless I'm hearing argument from Ms. Middleton.
Again, Your Honor, we do not disagree with the procedural history of this case. We started the case on November 26th. We have been having difficulties getting the file. So, I do apologize if my knowledge of the case isn't exactly in alignment with the procedural history of the case. So I do want to be honest about that. But, again, we would want to move to withdraw and amend the admissions, based on the previous procedural history of this matter.
So when you came into the case, you came in relying on what Mr. Gillespie filed, and you didn't file your own or amend?
We did rely on the Felicetti firm, which was the firm that Mr. Gillespie worked for. I knew that he relied on ChatGPT for the filings, and I knew that was an issue. But in terms of the admissions, I really wasn't aware of that.
The issue is, and I know you know this, Judge, so this isn't going to educate you, but the problem is for them to be able to withdraw and amend their admissions, they have to show that the admitted under InterSouth Properties versus Contractor Exchange, which is 199 Georgia App 726, the admitted request either can be refuted by admissible evidence having a modicum of credibility or is incredible on its face. And at this point, there is no evidence in front of you at all to refute the admissions. I mean, that's the problem.
No affidavits, no certified copies, no
medical record
filed with
There's just nothing. So there's one 5-paragraph affidavit that we've already shown is not even reliable. So I'm sympathetic with Ms. Middleton. She's only been in the case for a couple of months, but at the same time, you don't always inherit the best cases, I guess. It's just how it goes sometimes.
Well, and this is what I say. Knowing the procedural history of the case, at that point, if I'm coming into a case that is problematic, I would amend the filings. I would ask to file I would ask for leave of court if necessary, but I would definitely amend the filings that were already done to preserve the issue, but to amend them to perfect them such that by the time that we actually argued the case, then the amended filings would take care of whatever deficits were done before. There's nothing that prevents you from amending a pleading. There's nothing that prevents you from, if your response was done by the previous attorney, coming in and amending and updating that response or providing additional evidence that would support the and give the court a basis for the decision to overturn the fact that the admissions have been deemed admitted.
Or bringing evidence or witnesses to this hearing. There's a lot of ways to do it. But Your Honor, I think you could issue an order in such a way that it wouldn't extinguish any claim that the plaintiff may have, not against my clients, but if that's of concern.
Is this a first filing? This is not a refile?
To my knowledge, it's not a refile.
My knowledge as well, Your Honor.
Although, if I'm not mistaken, maybe I'm getting my cases mixed up. I think the complaint says it's a refile, but I was never aware of a first filing. I'm gonna look right now.
All right. Okay, so the court is going to make a decision in this case, and I will issue an order. Mr. Kennedy, if you will get me an order on the sanctions, I'll go ahead and sign that.
Okay.
All right, Ms. Middleton, the cases are what we get. I was in civil practice too, so I understand that sometimes if you take over from another attorney, it kind of is what it is. But let me have some time to consider all of the. I'm not a superior court judge, so I can't balance the equities, as it were. But I do have to consider, fairness and balance those things that would affect each of the parties in this case. So, all right. Thank you, Mr. Kennedy. Thank you, Ms. Middleton. And we will get an order out to you.
Thank you, Your Honor. The only, before we go, if we could, and this may be something that I can work out with Ms. Middleton, I don't know, but we do have the motion to open the default as to liability and set aside the liability judgment as to Peachtree Truck Leasing Company.
Peachtree Truck Leasing, right.
Right, which we were going to take up in August, and then we never got to it.
Yeah. So what we had talked about was the default was in, and then we were talking about whether a damages hearing would prejudice the remaining parties in the case because of the information that had to be presented during the damages hearing. And so that's sort of where we left it before all of the issues with the briefs.
Right, and so you already ruled that we couldn't have a damages hearing because there was still one defendant that wasn't in default. This is a slightly different issue because I'm asking you to open the default and set aside the judgment as to liability as to Peachtree Truck Leasing altogether because they're an improper party in the first place. And I told Mr. Gillespie, but I'll tell Ms. Middleton now. I know who the proper party is. I've put it on all the briefs. And all I'm asking is that we just swap out the parties so we get the right entity in here. I'm not trying to hide the ball or extinguish any claims or anything. We're just trying to get the proper parties in. And Mr. Gillespie was, I guess, holding on to his default judgment that he'd gotten as to this Peachtree Truck Leasing, which again is not a proper party, and we didn't want to agree to lose that. I don't think the plaintiff is prejudiced at all by getting the correct defendant in here and litigating on the merits, since we already have Mr. Nellums has not been in default at any point. But that's the issue there. And again, maybe Ms. Middleton.
Okay, let me ask this. Do you also represent the proper entity?
I do, yes. So there won't be any issue with that.
All right.
Yeah.
Yeah, we would not want to keep the wrong entity in, so we'd have no objection to that.
Okay.
Okay.
I can put that in a proposed order too then if you want. If you want to.
Please do.
All right. All right, I think that was the only other thing on the table.
All righty. Thank you all.
Thank you.
Thank you. Thank you, Your Honor.